Welcome to your version of Bold Bits. It's January 12th, 2016. Let's take a look at Bold IP. We don't feature Bold IP too often. The website is actually pretty informative, and what I want to show you today are the specifics of patent prosecution. As you can see, if you click on the Services tab, one of the service areas that Bold IP offers is patent prosecution. Go ahead and click on that. You'll see the patent prosecution services come right up. There's what's called Prefiling, and before it's submitted to the USPTO, we recommend a patent search, either a portfolio analysis or invention harvesting, meaning what inventions do you and your team have that you may not even know that you have while you're innovating and creating products or services. Once it's been submitted to the USPTO, in the process of doing that, we offer numerous different ways to submit that, through design applications, utility applications, and plant patents. Today I want to talk about one thing that most firms will usually not disclose right up front, and that's pricing. At Bold IP, we are indeed bold, and we do want to share that with all of our clients, especially on the most common application types. So for utility applications, which are the most common, if you scroll to the bottom of this page, we do offer a chart. And if you can see this, a little bit small, this is the ABCs of the patent utility application flow and cost. We typically start out with inventors here in this black triangle, where we offer an initial consultation free of charge. Then we discuss whether the idea is even eligible for patenting. If it is, we usually recommend a patentability search. These are the costs on the low end, something more easy like a mechanical device. Think toothbrush, ironing board, something very mechanical and fairly straightforward. On the upper end, think more software, very complex electrical circuits, that sort of thing. The time frame is generally 3 to 4 weeks for the patentability search, and the inventor will get from that a legal opinion with whether the patent is recommended to be filed or whether there's enough prior art that we recommend against filing. The next step is to do either a provisional or a non-provisional application. A provisional application provides a priority date, and it is that patent pending that most investors are looking for. So it's a popular package to go ahead with. It's not required, however. One could jump directly to a non-provisional application, and if they do, these are the prices here. If the inventor decides to go with a provisional application first, and within that year of provisional application being pending, they then file a non-provisional, the price they paid for the provisional is subtracted from the non-provisional. So, for example, if someone has a $5,000 provisional application, their non-provisional application fee will be reduced by $5,000. A lot of the application work that's done in the provisional can be carried forward in the non-provisional. Thank you for tuning in for this week's Bold Bits. If you have any questions, feel free to get a hold of me or info@boldip.com. Thanks and have a great week. Go big, go bold.
Go big, go bold at boldip.com.